My name is Rick Wheeler, the founder, president, and legal counsel for Adjuvant Pro Incorporated. Today we're going to talk about the power of a revocable living trust. The key question I often ask people is, do you have an estate plan? And many people don't know what an estate plan is, but essentially it's a written strategy that you make now, and at some point in the future you execute that strategy or someone executes it on your behalf, and that would be if you become incapacitated or pass away. Without an estate plan, the courts will make a decision as to who will care for your children, who will actually take care of you if you need long-term care, who will manage your assets if you're unable to do so, how, when, and to whom your assets will be distributed. So the question is, would you rather make those decisions, or would you want to leave it in the hands of the court? Let's move forward now. Let's talk a little bit about what is included in an estate plan. Most estate plans will include a simple will. Many times they'll include what's called a springing durable power of attorney. The concept of a springing durable power of attorney is basically that in the event you're unable to make your decisions, you already have a document in place that will indicate who you'd like to make your financial decisions. And generally it doesn't go into effect until such time as you're unable to make those decisions. The next document that's generally included in an estate plan is an advanced health care directive. Different states have different names for this, but essentially what it is, it's a document that you prepare beforehand that indicates who you'd like to make your medical decisions for you, and in essence what type of decisions you'd like made. This goes into effect when you're unable to make those decisions. A fourth document that many times is included in an estate plan is a revocable living trust, and also includes what's called a pour-over will. A revocable living trust is something we really advocate for those who need it, because it gives a lot of flexibility in how to handle your assets and your estate, both while you're alive and then later on when you pass away. A pour-over will is kind of like a safety net that whatever is not put in the living trust, if you were to pass away, it automatically transfers that into the living trust. So you may be wondering, do I need a will or a living trust? Well, let's compare wills with living trusts for just a moment, if we may. The first thing about a will is that you may be required to probate the estate if you only have a will. This can be a costly and time-consuming process, but depending on the value of the estate will determine whether or not you actually need to put the estate into probate when someone passes away. The second thing about a will is that it does become a public document. That means that people can go down and observe what's in the document. They can observe who the executor of the estate is. They can look at who stands to inherit and how much they stand to inherit. So privacy basically goes out the window with a will document. One of the good things about a will is it can be changed while you are alive. A will generally costs less than a revocable living trust. However, when you take into consideration the cost of probating an estate, a will may actually be more expensive overall. One of the beautiful things about a revocable living trust, it gives you the option to avoid probate court. The living trust provides a higher degree of privacy because the document is generally not deposited with the court, so it remains essentially on your shelf somewhere, only available to those that need to see it. A living trust can be changed while you are still alive. This means you maintain control over your assets while still living. Once you pass away, the living trust locks into place. A revocable living trust generally costs a little bit more than a will. However, a living trust is less expensive overall than the cost of a will, generally because you don't have to pay probate costs and costs associated with probating the estate. It also avoids the costs and inconvenience of formal conservatorship proceedings. It also provides continuity of management of your assets, uninterrupted by your incapacity or death. In other words, it's seamless. So with all of these wonderful estate planning tools out there, why do 55% of those who die without an estate plan? Some say they just don't have time to make out a will or a trust. Others think that they're so young they still have time and they'll just do it later. Oddly enough, there's a lot of people that think if they make out a trust or a will, it means they're planning to die. And some say they just can't afford it. And there may be other reasons as well. Bottom line is that we all need some kind of an estate plan. So what are the probate costs and the costs of a will compared to the cost of a living trust? Probate costs can be up to 4% or more of the value of your estate. So for the purpose of an example, let's say you have an estate valued at $150,000. You're probably looking at somewhere in the neighborhood of $6,000 probate costs related to that estate. Compare that to the cost of a living trust, which can be up to $2,400. So as the value of the estate increases, you can see that probate costs also increase. So for example, an estate valued at $250,000, for our example, the probate cost is estimated at $10,000. Again, if you had a living trust, you're probably going to spend up to $2,400 for that. And next to that is the $350,000 estate value. You're looking at probably a probate cost of $14,000, give or take a little bit. But the trust cost, again, is up to $2,400. So I've given you lots of information today, but in order to try to make sense of all this, we put together a case study of Jim and Sally. Jim and Sally have an estate with enough value in it that it must be probated. Our example is going to be if they had an estate of $150,000. They have 3 children under the age of 18 years, in other words, they're minors. Their son Donnie, age 21, has a severe drug problem. And then Jim's brother Bob lives in town, has different values, different beliefs, doesn't even like children. Sally's sister, Sarah, lives 100 miles away. Her values are similar, and she has the same religious beliefs as Jim and Sally. She and her husband have 1 child, and they love children. Jim and Sally wanted to give money to their favorite charity when they die. Jim and Sally are both killed in a car accident. So what happens to their children and assets? It depends. So let's look at 3 scenarios of Jim and Sally. First scenario is that Jim and Sally don't have any will in place. They don't have any kind of an estate plan. They've died intestate. The court decides to send the children to live with Uncle Bob, let's say. The court distributes assets equally among the children. That means Donnie gets the same amount. Remember, Donnie has the drug problem, so Donnie uses all his inheritance for his drug habit. They had a favorite charity, but the favorite charity receives nothing. Their estate information is made public. The good news is they did save about $400 on the cost to draft a will. Their estimated probate cost is $6,000. Their total cost estimate is about $6,000. Our second scenario is that Jim and Sally did create a will. They had a will put together. In the will, they wanted the children sent to Sarah, so the courts honored their wishes and actually sent the kids to live with Sarah. The court distributes the assets according to their wishes. Donnie's inheritance is placed in a trust, and he's able to receive that inheritance if he shows that he can be clean for 3 years. Their favorite charity receives a really nice gift. Their estate information, however, is still public. They spend the $400 to have their will drafted. Their estimated probate cost is about $6,000, so their total estimate is about $6,400. In our third scenario, Jim and Sally decided they wanted to put together a living trust. In their living trust with their pour-over will, the will indicated that they wanted their children sent to Sarah, and again, the court honors their wishes. The trustee distributes assets according to the trust, and Donnie's inheritance again is placed in another trust, which he is able to receive if he's been clean for 3 years. Their favorite charity receives a nice gift. Their estate information, however, is kept private. They spend up to $2,400 to have the living trust created. They don't have any probate costs because they decided not to probate the estate. And their total estimated cost is $2,400. I want to thank you for listening to our trust presentation and hope that you found it very helpful and informative. If you'd like more information about a living trust, or if you'd like Edgevent Pro to draft your living trust documents, then contact the person that gave you this video, or you can call our corporate office at 1-800-942-7450.